Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to do part 3 of our series on tort law that deals with strict liability and strict liability cases. So let's head on down to the beach and talk about that. What is strict product liability? Well, strict product liability is the ability to hold someone accountable for a dangerous and defective product without having to prove that the manufacturer or the designer or the seller was in some way negligent or did something wrong. Basically, you can say that it is the way to hold people accountable for products that hurt people. One of the most interesting aspects of strict liability, and this is why they call it strict liability, is if somebody is hurt by a product because of a defect in that product, then in most cases, they are going to recover something in court. Now, that's not always the case. The purpose behind that, again, as I've mentioned previously, the purpose behind strict liability laws is to, as between the consumer who bought the product in good faith, not knowing there was anything wrong with it, and the manufacturer who created the product, which of the two should bear the cost of those injuries? Well, clearly it should be the person or entity that had the last clear chance to avoid inflicting that injury. And in this case, in the case of a product liability or a defective product, it would be the manufacturer, because they obviously either didn't test or test the product well enough to find that there is a defect, or in the alternative, they did not warn of a defect that they knew about. So what are the elements of a claim for product liability? First, the product was unreasonably unsafe at the time it was sold. In other words, it has to come from the factory in a defective condition. Now, product liability applies to things like automobiles when they leave the factory in Detroit or wherever, Tokyo, wherever these cars are produced. And in addition, it applies to things like drugs, which are released into the stream of commerce after they have been approved by the FDA. Well, you may think, well, if the FDA approved them, then how can you claim that the product is defective? Many times the defect in a product doesn't show up, particularly if it's a drug, doesn't show up until 3, 4, 5 years later. And then you can start looking at the data and say, wow, it certainly seems like there is an increase in the number of people who have had cardiac events after taking this drug. And then additional research will often lead the FDA to issue what's called a black box warning. From that information, you can determine that the product was unreasonably dangerous at the time that it was sold. Now, the next element is that the product was not modified. Obviously, in a drug situation, that's rarely the case that the consumer would modify the drug. But certainly in the case of something like a lawnmower, a consumer might modify the product. He might decide that he doesn't want a side discharge, and he might put something on the mower that prevented the side discharge, and in so doing, somehow cause a problem within the mower that causes it to fail. Now, I don't know for sure that that's ever happened, but that's just an example. You can modify a piece of equipment. And if you modify the piece of equipment and the modification in any way impacts its performance, such as to make it unreasonably unsafe, then as a result, you lose the product liability lawsuit. You have to show the product was not modified. The product was used as it was intended. So, for example, the product is a lawnmower and you use it to mow the grass, okay, you've probably got a claim. If you pick it up and you try to use it as a hedge trimmer, you probably don't have a strict product liability claim on product design or product defect, but you may have a failure to warn claim. We'll talk about that in a minute. The product caused the plaintiff to suffer harm as a direct and foreseeable result of problems with the product. In other words, for example, when Fin was a big item that was out there and people were using it to lose weight, Everybody was using it exactly as was directed, and it wound up causing heart valve defects and a number of other serious heart complications. And as a result, the manufacturer got sued. And because they had all these problems, they were entitled to damages. And the damages that I think were paid in FinFin were up into the billions of dollars. So there are three basic types of claims that are strict product liability claims. One of them is the design defect claim. And that's an error in the design process that led to the product being defective. A better design would have prevented the harm. Manufacturing defects. The product was properly designed, but in the manufacturing process, defects were introduced by using products not up to specifications. So, for example, in the Kansas City hotel, the Hyatt hotel disaster, the architect specified a certain kind of bolt that was to be used to hold the skywalks up. And unfortunately, the engineers who installed the skywalks used a different bolt that wasn't up to the task. And so there was no defect in design, but there was a defect in how they were installed or manufactured. And then marketing defects, where you tell someone that a product is safe for use in a particular way. For example, Roundup being safe to use on weeds. And then later on, learning that the key ingredient in that may cause autoimmune problems. In that situation, it was marketed as being safe when it's a toxic chemical and people didn't know. And then in addition, the failure to warn claim. That's where a latent defect exists in the product that the manufacturer knows about, but doesn't provide notification about the risk of its product. And we'll see that in the case that we're going to look at here in just a little bit. And then a breach of warranty. A breach of warranty occurs where you have a product, for example, in the sudden unintended acceleration cases, the manufacturers were charged with a breach of warranty because even though people took their car back 2 and 3 times, the manufacturer could never remedy the defect that the consumers had. And of course, the defendants get a voice in all of this. And here are some of the things that defendants say. The plaintiff used the product improperly, not how a reasonable consumer would use it. That's the example of somebody picking up a lawnmower and holding it up to use it to trim hedges. The plaintiff knew of the danger and assumed the risk. So, for example, if you have a product that uses electricity and you happen to drag the cord through a mud puddle and you wind up getting shocked or electrocuted, well, that's a situation where you knew what the risks were and you assumed those risks. The utility outweighs the risk of harm. So here you have a situation where there's been, I'll give you a really good example. We did an investigation once of a garage door opener. And the garage door opener, when you hit the remote, the motor turned on. And when the motor turned on, there was a spark. Now, in 99.9% of the times that this happens, nothing happens that's bad. But on this particular day, the gentleman left a can of gasoline uncapped in his garage. And the fumes of gasoline permeated the garage. And when he walked in and smelled it, he realized, oh gosh, I've got a lot of gas in here. I probably need to vent the garage. And he hit the remote for the garage door opener, and the explosion blew him out the window. Now, because there had never been a similar event like that, the manufacturer wasn't on notice and didn't have a need to warn. And in that situation, because there were no other similar incidents to that, we felt that we probably wouldn't be successful in a product liability claim for that reason, because the utility of a garage door opener outweighs the risk of harm. And then finally, defendants always point to somebody else to blame. It's the garage door installer that is to blame, or it's the doctor who prescribed the medication. It's his fault. or it's the mechanic who worked on the car, it's his fault. There's always going to be somebody else to point the finger at. Jurors are usually pretty good at figuring that out. So let's take a look at some example cases. If your vehicle's airbags fail to work properly, you have a product liability claim. The airbag's there to protect you. If it fails and you're injured, then the airbag was defective. It was used as it was intended. You didn't modify it. You were injured as a result. It's a perfect product liability claim right there. What about sudden unintended acceleration? Your car suddenly accelerates for no reason. You get in an accident. It's probably due to a design or manufacturing defect. A lot of times these devices use sort of what's called fly-by-wire technology, where the computer is controlling the acceleration based on inputs that it receives from sensors in the pedals. There used to be a hard linkage between the accelerator pedal and the motor, and now it's all taken care of by sensors and wires as opposed to actual mechanical devices. So the car is always supposed to be under the driver's control. If the car accelerates without being directed to by the driver, it is defective. It could be design flaws or it could be manufacturing flaws. And here's another good example, defective fuel systems. This is Anderson versus General Motors. It's a case from several years ago, I think 1990. But the jury ordered General Motors to pay $4.9 billion to the Anderson family for a defectively designed fuel system that caused their Chevy Malibu to burst into flames after it was rear-ended in 1993. So that's a situation where the defect is latent and it's only apparent after something else, some opposing force causes it to occur. There have been a lot of cases, particularly people like highway patrol officers and family members who are injured or killed in wrecks because they are rear-ended and the gas tank is either not secured or it's secured in such a way that when it is hit from behind, instead of dropping down and moving away from the car by the force of the impact, instead it's crushed, the gas is released, there are sparks, and boom, you wind up having a big fire. Now let's look at a relevant Missouri case that involves strict product liability.
This is a case that involves a Ford Motor Company and a product liability action, and unfortunately a lady who was a little bit too big to be driving a car perhaps, or riding in a car perhaps, at least from Ford's point of view. She and her husband were sitting at a light and they were hit from behind. And in that rear end collision, the seat that she was in collapsed backward. And when it collapsed backward, she hit her head and upper back with severe force on the back seat in the Explorer. And as a result, she suffered an injury at T9, the ninth thoracic vertebrae, and that injury was sufficient to cause her to be paralyzed from the waist down. So in looking at the case, they tried the case as a product liability case, and they also tried it as a failure to warn case. In the product liability case, they said that the seats were defective and unreasonably dangerous because they were designed so that they were more likely to collapse in a rear-end collision when being used by an overweight person. Ford defended that, and a jury agreed with Ford. So the design defect claim was thrown out by the jury, and they didn't get anything on that. With respect to the failure to warn claim, however, the trial court granted a directed verdict at the close of the evidence, the plaintiff's close of the evidence. Now, a directed verdict basically says you didn't supply enough information from which a jury could give you a verdict on this failure to warn claim. So they appealed specifically on this failure to warn claim. The court did feel that there was a sound failure to warn claim here and that enough evidence supported it so that it should have been submitted to the jury. Moore's counsel explained their failure to warn claims during his opening statement as follows. The third reason we've sued Ford arises from simple common sense. Nowhere in the owner's manual or on the on-product labels did Ford tell people who might use the Explorer that it intended the front seats to collapse in a rear impact. That's information we contend in this trial that people are entitled to know before they sit in those front seats. Just as important, I think, that's information we contend in this case that people are entitled to know before they put their children or loved ones behind those seats. None of that information was given to consumers by Ford. If Gene and Monty would have been warned by Ford or instructed by Ford that the seats in the 2002 Explorer were intended to collapse in a rear impact, they may have never bought the car and we wouldn't even be here. Mr. Moore testified that his wife, because she was a person of size, tended to read warnings and that he did not see any warnings or markings on the Explorer seats that they were not designed for people of her size. Mr. Moore also testified without objection that had Ford provided some warning or indication that the seats were not designed for people of Ms. Moore's size, he would not have purchased the vehicle and would have done everything in his power to prevent his wife from riding in it. At the close of the Moore's case, Ford moved for a directed verdict, and in opposing that motion, they made the further statement that the subject Explorer is devoid of any warning whatsoever telling its customers like Gene that the seat in the Explorer is dangerously susceptible to breaking and collapsing in a mild to moderate impact when holding an occupant of Mrs. Moore's size and weight, or that this condition leads to a loss of restraint that can allow an occupant to strike the rear seat, causing spinal cord injuries and paralysis. In spite of that, the trial court granted the motion for a directed verdict on the failure to warn claims. The Moores contend that they made a submissible case of strict liability for failure to warn, in that the Explorer lacked any warnings that the front seats could collapse in rear impacts and were not tested or designed to perform with occupants of Ms. Moore's size. The elements of a cause of action for strict liability failure to warn are 1. The defendant sold the product in question in the course of its business. 2. The product was unreasonably dangerous at the time of sale when used as reasonably anticipated without knowledge of its characteristics. 3. The defendant did not give adequate warning of the danger. 4. The product was used in a reasonably anticipated manner. And 5. The plaintiff was damaged as a result of the product being sold without an adequate warning. Failure to warn claims are concerned with how a lack of warning about a product and the user's resultant lack of knowledge about the product's dangerous or safe use may give rise to an unreasonable danger to the consumer. Various decisions of the Missouri Court of Appeals have explained this distinction as even though a product may be designed and manufactured properly, the lack of an adequate warning in itself may render a product defective or unreasonably dangerous within the meaning of the law. A lack of adequate warning in itself renders a product defective or unreasonably dangerous within the meaning of product liability law. So as a result, the win for Ford, at least on the failure to warn claim, was reversed. It got sent back to the trial court, and assuming that because for whatever reason it doesn't look like the case was further appealed later on, it looks like perhaps the Moores were successful when they went back and tried the failure to warn case. But that's a good example of a product defect claim because they brought claims not only for a design defect, and I'll be honest, I think the experts probably bamboozled the jury here. They just confused them with enough contrary evidence to get them to buy into the theory that it was okay to have seats that collapsed backwards. It really is not okay to have seats that collapse backwards. The entire reason why every car manufactured after 1966 has a headrest is to protect the neck in a rear-end collision. Because in a rear-end collision, thinking of Newton's law, for every action there's an equal and opposite reaction. When you are struck in the back, going one way, your head goes the other way in response to that. That's just simple physics. So it's hard to believe that that was not an unreasonable design, but they convinced the jury that it wasn't.
Well, that's all I have for you today. Thank you very much for watching. If you have any questions, please leave them in the comments down below. You know, all the stuff all of us YouTubers ask you to do: like, share, subscribe. I would really appreciate that. Anytime you hit a like, it helps my channel. And if you have the opportunity today, please take some time to go do something nice for someone. It really will make your day better. Thanks again for watching, and have a marvelous day. Catch me down here next time at the beach.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.